Hi, starting with the 3rd December editorial. The first editorial is Staring at a Slowdown. This editorial speaks about the demonetization. It mainly focuses on the negative points of the demonetization. Now, let's instead of looking at the few points, let's look at the overall picture. So, let's see the positive and negative of the demonetization. So, coming to the positive, they are divided into three parts. First is in handling corruption and terrorism. Second, related to banking system. Third, related to economy. First, the demonetization is very helpful in dealing with the corruption to limit the black money because there will be fear of getting penalized and prosecuted by authorities. Second, it is also it plays a very important role in dealing with the counterfeit currency and limiting or having a check on smuggling of arms. Now, second is the banking system. Then banking system demonetization will be a boost to the banking system as more money enters due to the increase in the deposition. But what has to be seen is how much money will remain once people start withdrawing. Then it is also very important in transforming a society into a cashless society with the digital transaction. But the positives of digital transaction is that it reduces the risk of cash handling by the bank, and it also increases the credit access and the financial inclusion. And the long term impact of the demonetization is that there will be a decrease on interest on the loans. Then third is the impact on the economy. It reduces the tax avoidance as income tax officials will have keep the track of the money deposited or exchanged. So it may also lead to a search and seizure activities from the IT authorities. So it curbs the malpractice. So, due to the reduction in the tax avoidance, there will be an enhancement of the tax base. So, this reduces the fiscal deficit to the government. Plus, another positive point is that it reduces the government liability because every note is a liability for the government because government just can't print the notes. It has to be backed by some kind of security. So, suppose a person has lot of black money, so he doesn't want to show it to the officials, so he decides to hide it. So that much amount is removed from the economy. So this reduces the government liability. The long term impact will is that there will be an increase in the income tax collection. So this might lead to the reduction on interest on the loans. So this increases the disposable income available with the people, and thus leading to the increase in the consumption demand. Even though for the short term there will be a decrease in the demand, in the long term there will be an increase in the consumption demand. Now, coming to the negative effects of the demonetization, first, considering the sector with high level of cash transaction like real estate, jewelry, restaurant, retail, automobile, consumer durables and luxury brands and cement, at least for short term, there'll be instability in the sectors, and if there's any industry which with a high debt, it might face more pressure, and it also there might be a chances of loan defaulting. And another impact is that there'll be decrease in the spending, like it can be either in the decrease in the consumption or decrease in the investment. Therefore it leads to the decrease in the employment, thus leading to decrease in the GDP. The reason for the decrease in consumption might be like there'll be if you spend more, there might be a scrutiny by the IT officials, and the tax law remains open to interpretation at the mercy of the tax authorities with no effective legal courts. So there'll be fear in the people to spend more. Now, coming to the banking sector, there will be an increase in the cost of operation of ATMs to the banks. Plus, it's difficult to create a cashless society immediately because many are not, versed with handling the ATM cards. Then next impact. Okay, and coming to the villages, due to the less penetration of banking channels, there will be a difficulty in exchanging the older notes. Another sector with huge impact is the informal sector. Informal sector which employs more than majority of workers and the most of its transaction is in cash. So therefore, the disruption in this system it might endanger the employment and livelihood of the weaker sections of the society. Now the question is what has to be done. So first thing is government and the RBI has to come with this stimulatory fiscal spending program for the people. Second, uh, it has to be coupled with a weaker exchange rate and shouldn't control the and we should control the depreciation of the rupee. Third is they're very much essential for the transparent rules, so as to prevent further generation of black money, and also changing our tax rule so that it is not left to the mercy of the IT authorities. The next editorial is Making of a Legislative Court. In this editorial, again, it speaks about the recent Supreme Court order to play the national anthem before the screening of a movie in cinema theatre. The special thing about this editorial is that it draws an analogy between this recent order and various orders by the courts, and it also draws the similarity between the recent order of playing the national anthem to the 42nd Amendment. Now, going to the editorial. First, the editorial speaks about the various court orders. First, to begin with, the Madras High Court mandated that Tirukkural be taught in all schools in Tamil Nadu. Tirukkural is the classic Tamil Sangam literature. And then there is this Supreme Court is also considering making yoga compulsory in schools. And the author says there are similarities between these orders and the recent order of playing the national anthem. So the common attributes are, first is that it's all from the PIL jurisdiction. Then it heavily depends on the fundamental duties or directive principles than fundamental rights. That is, more importance is given to the fundamental duties and directive principle compared to the fundamental rights. And the third important thing is that judges do not feel any need to justify their decision in legal terms. Now the writer compares the judgment to the 42nd Amendment. Before going into this, let's look at the 42nd Amendment, as it's very important in the in respect of PT and mains. 42nd Amendment was passed in 1976. It was called Mini Constitution. It gave effect to the many recommendations of the Swaran Singh Committee. Now, looking into the provisions of the 42nd Amendment, which is very important, especially in the PT point of view, first is that it added three more words into the preamble. Those are socialist, secular, and integrity. And it also added fundamental duties as a part 4A into the Constitution. Then it added three new directive principles. It also added three new directive principles. First is that of equal justice and free legal aid. Second is the participation of workers in the management of industry. Third is the protection of environment, forest, and wildlife. It also made that the president is bound by the advice of the cabinet, and it also declared that the emergency can be proclaimed in any part of the country, not necessarily the whole country. And another important thing is that it shifted five subjects from the state list to the concurrent list. These five subjects are education, forest, protection of wildlife, weights and measures, and administration of justice, and also the constitution and organization of all courts except the Supreme Court and High Court. This is important from the PT point of view, as they might ask the subjects in the concurrent list. Then the other provision was that creation of the All India Judicial Service. The provisions which we saw, the one which were approved. Now there were other provisions in 42nd Amendment which was declared unconstitutional by the court. Now let's look at those provisions. First is that it curtailed the power of judicial review and writ jurisdiction of the Supreme Court and High Court. And the next one is that it declared that the constitutional amendments is beyond judicial scrutiny. Another provision says that the laws made for the implementation of directive principles cannot be declared void by the court. And there was also a provision which empowered the other provision is that it empowered the parliament to make laws against the anti-national activities, and such laws were to take precedence over the fundamental rights. Other provision is that it raised the tenure of the Lok Sabha and State Legislative Assembly from 5 to 6 years, and it also increased the one-time duration of the president rule in a state from 6 months to 1 year. All these provisions were declared unconstitutional by the Supreme Court. Now, coming to the conflict between fundamental rights and directive principle, first it began with the Champakam case, which said that fundamental rights are superior than directive principles of state policy and Parliament can amend the fundamental rights. Then in Golaknath case, the Supreme Court declared that the Parliament cannot amend the fundamental rights. So to challenge this, the government came out with the 24th Amendment, which said that Parliament can amend the fundamental right. Then government also came out with the 25th Amendment, which said that Article 39B and C in the Directive Principle of State Policy is superior than the Article 14 and 19 of the Fundamental Rights. Article 39B of the Directive Principle states that the equitable distribution of material resources of the community for the common good. And 39C speaks about the prevention of concentration of wealth and means of production. So, in order to give effect to these two provisions, the Parliament can make law which can override the fundamental rights of the in Article 14 and 19. So, Article 14 speaks about equality before law and equal protection of law, and 19 speaks about the protection of 6 rights regarding the freedom of speech and expression, assembly, association, movement, residence and profession. And government also said that such law cannot be questioned in any court. In Keshwan is invalid, and then in Keshwan and the Bharati case, the Supreme Court declared this provision, that such law cannot be questioned in any court, as invalid. But it approved that the Article 39B and C of the Directive Principle of State Policy is superior than the Article 14 and 19 fundamental rights. Then government came out with the 42nd Amendment, which said that the Directive Principle of State Policy is superior than the fundamental rights. So, in response to this, in Minerva Mills case, the Supreme Court declared that the fundamental rights are always superior than the directive principle of state policy, except for the articles 39B and C of the directive principle of state policy. So this was in mains and PT's point of view. Now coming to the editorial, the writer draws similarity between the recent Supreme Court order of playing the anthem to that of the 42nd Amendment. He says that there is lot of importance given to the directive principle of the state policy and the fundamental duties compared to the fundamental rights. Plus, that there is no justification provided for this order is still a concern among the citizen. This is the brief about the two editorials. Hope this video has helped you. Please like and subscribe to my channel, and please give me your comments or feedback. If there's any improvement, I will definitely do it. Thank you.